the second week of land, and today we are motivated by this quote, which states that the best way to create the future is to create it. And I cannot explain it more than that. So land transactions, module 2, leases, tenancies, and acquisition. So basically we're going to look at lease as a tenure of land ownership. We're also going to look at tenancies, basically the landlord and tenants, and also we look at how do you acquire land. And basically in this workshop we shall be dealing with compulsory land acquisition. So you have to understand that the constitution gives you different forms of how you can own land in Uganda, and among those forms of land ownership, we have what we call freehold system, we have customary system, we have mile system, as well as leasehold. So basically that's why it's important that this workshop just proceeds on Article 237, which basically provides for land ownership in Uganda, and to it specifically for this workshop we shall be dealing with leases. So we are all aware that under the Land Act, leases are a creation of law, but also they are governed by statute. So you have to look at the Land Act, basically Section 3, because Section 3 of the Land Act, Section 2 gives you a land ownership system, which is a replica of Article 237, and also then goes on to explain leasehold as a tenure of land ownership, basically in Section 3, subsection 5 of the Land Act, as a creation of contract, but also as a creation of the law. So you have to really understand the principles governing land tenure system. But to wit, for this workshop, leasehold as provided for in Article 237 of the Constitution. So the module deals with the following: the creation and termination of lease. So I have already told you that under Section 3, subsection 5 of the Land Act, a lease is created by either operation of law or it can be created by a contract. Then termination of lease, we're going to look at several ways under which a lease can be terminated. To it, by expiration of time, when there is a merger, by surrender, or by forfeiture. So those are some of the ways in which we can see how you can create a lease. And in this subject is always a subject of oral questions, because a lot of questions always come from this topic of leases and tenancies and also land acquisition. But also for purposes of exams, it's very rare that you will miss a question that wants you to apply leases or maybe tenancies. So that's why it's important that you pay attention, and by the end of this video I would have simplified for you the course of leases, tenancies, and acquisition, so as I give you a very good foundation. So the distinction between leases and other rights which are not proprietary but user in nature, such as tenancies and licenses, easements. So basically when we talk about tenancies, what do we mean? We have looked at joint tenancies, we have looked at tenants in common, but now here we're also going to look at periodic tenancies, tenancies at sufferances, and tenants at will. As we continue to discuss, let me hope that you understood what we call joint tenants. So under joint tenants, the parties own the property jointly. So that means the doctrine of survivorship applies. After one person dies, the property survives to the remaining or to the surviving party. Then when we talk about tenants in common, this basically means that they own the property together, but their percentage is specified. Their percentage is specified. So when we talk about tenancies, we look at tenancies. We look at tenancies by sufferances. So if you have if you had a tenant in your building who was paying you rent, then after the expiration of his rent, if he has not paid you but is continuously staying in your room or in your building, that one becomes a tenant by sufferance. Then we shall also look at the tenant by will, who enters the land with the consent of the landlord, but their terms are not clearly stipulated. We shall also look at periodic tenancies. Basically, periodic tenancies, these are the ones that pay rent in a given period of time, for example, for a month, quarterly, and in a year. So we shall also look at easements, for example, access to roads, and also access to a water body, or maybe access to a way. So those are all easements which are also applicable in this workshop. And we shall also look at different rights as created and terminated. So the interaction of rights between holders of such rights and the persons who grant them. Then compulsory acquisition of land for public use and purposes. Of course, under Article 26, sub-Article 2, I provide for what we call compulsory acquisition of land. But what is important to note there, they talk about prompt, adequate, and prior compensation before the government proceeds to take over land. And we have the case of Asman Ilumba versus Anthony General, who basically challenged the Land Acquisition Act, because the Land Acquisition Act was providing that the government can proceed to acquire land when it has not compensated people, and then the compensation can be done afterwards. But then the Constitutional Court stated that this was unconstitutional. It was against Article 26 of the Constitution, which basically provides for prompt, prior, and adequate compensation. So we shall look at that, and the process is how the government is supposed to proceed to carry out land acquisition. And these ones are in the Land Acquisition Act, to include, of course, notice, valuation, public hearing, and all the remedies available to an aggrieved party. Then we shall look at the instances in which a person with a proprietary interest in land may require access to a public road but has none and can only access it through the land of another who is unwilling to offer it. So basically, when we talk about easements, we talk about the dominant land and of the dominant land. I think you understand those terms as used in easements. We have the dominant land, which is supposed to, which always seeks to do what? To get easement. And we have the host land, but there is a term for that. So you have to look out for that and understand those terms. So by the end of this module, students will be able to, one, explain the basic principles of creation and termination of leases. We looked at that. Then subleases. So a sublease is where a lessee wants to sublease part of his lease. So that's what we call a sublease. So you are not basically doing away with the whole lease, but you're giving part to another person. But in most cases, this one is subject to the consent of the lessor. And also we shall look at variation of leases. So when we talk about variation of leases, when you want to change a term in the lease or vary the user, you do what we call a variation deed. We shall also look at surrender, whereby the lessor wants to give away the whole lease back to the lessor. We do what we call a surrender and have what we call a surrender deed. We shall also look at the merger, where the lessee wants to buy the lease from the lessor. So those are the terms you should be conversant with by the end of next week. So demonstrate the process of creation of leases and subleases. Then compulsory acquisition of land and the principles on easement for purposes of effectively taking on instructions to obtain an access to land. Demonstrate the difference between leases and other rights which are not proprietary but user in nature. Then enforce provisions of leases and also recognize and deal with ISCO issues relating to leases and subleases. So what are the ISCO issues? Of course, we shall always look at lawyers not overcharging. We shall always look at lawyers not overcharging, but also the district land boards or the lessor must make sure that they abide by the terms of the lease, and also the registrar in registering these leases, because a lease must be registered under section 54 of the LRTA. It used to be section 54 of the LRTA, but I'm yet to find out whether it was revised, but it's still section 54 of the LRTA, which provides that instruments are not effectual until registered. Then from there, we shall go on to look at, of course, the law applicable. Then we shall look at leases. Of course, in Street versus Montford, the court explained what are the characteristics of the lease, and said that there must be exclusive possession of the lessor, and it's also governed by contract, and it can also be by operation of the law. So you have to read the case of Street versus Montford basically on the law of all characteristics of a lease, and it must be for a given period of time. Then tenancies generally. So you have to read this case of Busiro Farmers. Basically, it defines who are tenancies, but a tenant is a person who has rented a new building under the Landlord and Tenants Act. So they also are entitled to their rights. Then we shall look at licensees. So licensees are the people who have entered on your land with your permission. Then we go to facts. So Oman Benson is interested in acquiring 2 parcels of land. These certificates of title are here to attached and marked as property A and property B respectively. So I got the benefit of looking at these deeds. Property A is a private milo owned, I think, by Daniel Ahumza, and property B is a leasehold which was signed between Turhara District Land Board as well as Smart Investments Limited. So part of property A is developed with 3 blocks of old depleted structures. The rest of the land is vacant. Oman Benson intends to establish a beef processing plant on the land to take advantage of the very high demand for beef products in Uganda. So basically here what we have to understand is we have the Physical Planning Act. I think it was of 2010, but that act declared Uganda as a planning area. So basically that means if you're going to construct any structure, you must first seek consent from the district planning committee, which basically gives you permission. So he intends to renovate the 3 blocks to use them to accommodate the machinery and storage freezers. He also intends to construct a large animal holding shed on the vacant part of the land in which animals will be kept for at least 2 days before slaughter, while feeding them on excretion stimulants enable them generate sufficient waste, operate a biogas plant at the site for lighting, warming and refrigeration, and also generate about 2,000 tons of rich manure every week for supply of farmers within the neighboring districts. The project is intended to break even in the 15th year of its operation. So basically here we are looking at biogas and all that stuff. So that means basically we have to proceed under the NEMA Act, and we see whether he must first obtain an environmental impact assessment to see what is the impact of all this project to the environment. So you know that if you're going to do any project where you might have an impact on the environment under the National Management Act, you must carry out what we call an environmental impact assessment, and it's your duty to do that and then submit to NEMA and get NEMA approval. So according to the facts here, we can see biogas and all that stuff. This might likely cause an impact to the environment, and that's why this person will need an environmental impact assessment. So Benson wants to own this land together with his 2 wives, Jonah Dunster, a German national who has 1 child with Benson and is contributing 1/2 of the startup capital for the project, and Mrunji Beauty, a Ugandan who stays at home typically as a housewife and has 7 children with Benson. So basically this means that on this property A, they are going to be joint tenants. So if you're going to sign a sales agreement, we should have all the 3 located, Benson, the German wife, and also the Ugandan wife. So who are also going to be what? They are also going to be joint tenants. But here the fact that we have this Germany, the Germany wife who has also stipulated his percentage of the share, because they didn't separate, so basically they are going to be joint tenants. So on the other hand, property B is fully developed with a storage commercial building and is fully occupied. The building currently has the following occupants. So basically I told you that property B is owned by Smart Investments Limited and it's under a leasehold from Turhara District. So the ground floor is occupied by a pharmacy, a restaurant, a salon and a dentist clinic respectively, each paying rent of Shinji 1.5 million per month, payable in 3 months in advance. So basically these are tenants. These are tenants who under the Landlord and Tenants Act. So on the veranda, there is a mobile money kiosk operated by one Jennifer, who pays some minimal fee of shillings 100,000 every month for being allowed to operate there from on. So this mobile money kiosk is a licensee. Mobile money kiosk is a licensee. On the same veranda is Mzee Black, a newspaper vendor who has been operating from there since the year 2000 with 2 newsstands, but also sells some other knickknacks like face masks, sweet pens, and like Mzee Black does not pay any rent and is not known to the landlord. So this one is now a trespasser by the fact that he's not known to anyone, so he doesn't have any rights to be there. So the first floor is fully occupied by a branch of Bet Africa Limited, a sports betting company paying USD annually, payable in 2 installments in advance. So the first floor, this is a landlord, this is a tenant, Bet Africa Limited. The second floor is fully occupied by Bradstars High School, paying shillings 6 million annually, payable in advance for every 2 years. This is also a tenant. The third floor is occupied by relatives of executive director of Smart Investments Limited, and they do not pay any rent. So these are tenants by will. So tenants by will are on the land with the consent of the landlord, but their terms are not clear. So this becomes tenants by will. So Oman Benson has instructed the law firm where you are employed to handle all the transactions relating to the land until he holds the legal interest in the 2 parcels of the land together with his 2 wives in respect of property A and solely in respect of property B. So advise Benson on the following: all the pertinent due diligence to ensure viability of the respective transactions. So I think we looked at due diligence in our first workshop, but basically we have the case which says that land is not vegetables, where you buy from unknown lenders. So you have to carry both searches on the registrar, physical search on the land, verify the owners, and also do what we call surveys on the land. So basically that's what some of the due diligence we're going to look at. And basically now remember, we have to also discuss the rights of these third parties on the land when we are tackling this question of due diligence. So B, the steps you would take to cause your client to obtain a proprietary interest in the respective parcels of land. So basically we have 2 parcels of land here. One is a freehold owned by Daniel Ahumiza, and also leasehold owned by Smart Investments. So as far as the private mile is concerned, I want to sign a sales agreement. After signing a sales agreement, we are going to fill the transfer forms. Then after filling the transfer forms, we are going to take them to the registry, of course, pay the appropriate stamp duty, and then after that we have to register them under section 54 of the RTA. You know, it must be registered under section 54 of the RTA. Then also, as far as the lease agreement is concerned, the Smart Board Company Limited, we have to have a board resolution from the company. Then after that, we shall have to sign a lease agreement. We shall have to sign a lease agreement with the company, of course, with the consent of the landlord. Then after that, what we shall do is we have to also proceed and register this lease agreement under section 54 of the RTA. Then after that, draft the pertinent documents. We have looked at sales agreement in private milo, and also lease agreement in with Smart Investments Limited. So C, the steps Benson would have to take to immediately lawfully obtain a physical possession of the whole of property B from the various persons currently in possession of the same, assuming that he intends to use entire building for his own personal venture. The steps Benson would have to take to immediately lawfully obtain physical possession of the whole of property B from the various persons currently in possession of the same, assuming that he intends to use the entire building for his own personal venture. So basically here you have to serve notices to the tenants, and you give them maybe 3 months notice that they should go out. For those ones who might have paid for more than those months, that means they will be compensated. But basically here we are looking at serving notices at these tenants, and then compensating those ones who might have paid beyond the required special time. So draft the pertinent documents. Students can draft only the document required for facts on the ground floor on part B. So basically, draft the pertinent documents. Here we are looking at I think we really looked at this in our previous workshop, but we have a notice to the tenants to a notice to vacate to the tenants. I think we looked at it in our previous workshops, how to deal with this. So basically that's workshop 1, and in case you need a third discussion group that's not going to waste your time, that's going to add value to you, and you get support from my community, which has students from all the 3 campuses. We have Lila, Mbarara and Kampala, but also a student of Mbare have started also joining. So in case you need a group, you can text me on the number on my YouTube, and then it's a payment of an affordable price per month to support the research, but then you will surely get value from the same. So let us proceed to workshop 2. Workshop 2 is more broad compared to workshop 1. So this workshop deals with the principles relating to termination of leases and subleases. It also deals with compulsory land acquisition and the principles on easements required for access to a public road. So I discussed these ones when I was introducing. So by the end of the workshop, you should be able to 1, explain the basic principles relating to termination of leases and subleases. So I've said that a lease can be terminated 1 by a fraction of time, that's the expiration of time, by notice, by merger, by surrender, and also by breach. So all those ones can be ways of terminating a lease. Then also looks at compulsory acquisition of land for public use, and this was under Article 26, sub Article 2E of the Constitution, as also guided in the Land Acquisitions Act. Then also looked at easements required for access to public road, and this one is always have to apply to the minister, and we have the Public's Roads Access Act. Then we looked at enforce provisions of lease agreements. For example, where there have been a breach, how do you enforce that? Draft various documents for the termination of leases, subleases, compulsory acquisition of land, and acquiring easements for purposes of assessing a public road, recognize and deal with issues relating to termination of leases and subleases. So we have the law applicable, the remedies under under leases. Of course, we have 1, forfeiture. You can right of entry and forfeiture is one of the remedies under leases. And compulsory land acquisition, we have this case of Asmani Ruba versus Anthony General, but here we have Praida Abdul Rasul Ismail versus Adriano Sibo, which also basically discusses that, and also Yunura versus Urumba Asman and Peter Mugela. And we shall also look at easements and access to leads, which has been discussed in the case of Barclays Bank versus Patel. Then other cases there too. So facts. Assume that both properties in workshop 1 have been legally acquired. Benson advised Benson on any further steps that he would have to take in order to lawfully establish and implement his personal venture in property B, if such venture is a hospital whose business break-even period is projected to be 20 years, and what's the pertinent document. So basically here, if you want to use the document for the hospital, then what we are looking at is of course you have to vary what we call the user, because the user was basically for commercial, and here you are going to put a hospital. So you have to go and seek you vary the user from the lease agreement. Then after that you look at what we call getting necessary permission from the physical planning committee. Then also you get approvals from NEMA and all those necessary approvals. Then draft the pertinent document. Basically here we are looking at the variation deed, basically, which is to vary the user of the lease, which was strictly for commercial purposes. Then part B, the steps you would take to address default in rental payments by each of the occupants in property B, assuming that when he legally acquired the premises, he retained them therein. So basically here we are looking at if the tenants have failed to pay rent. So basically you serve a demand notice, and then after that you can also do what we call re-entry, right of re-entry and forfeiture. So draft the pertinent documents as required in the first FRA only you look at a notice of motion, which is always supported by an affidavit. That's how you right of re-entry and forfeiture. Notice of motion supported by an affidavit. So part C, they are saying that the steps Benson's lessor would have to take effective terminate the lease in the event that when Benson eventually acquired and started utilizing property B, he defaulted on terms of the lease for a substantial period of time. So we discussed various ways of termination of leases. We looked at forfeiture, we looked at surrender, merger, and by expiration of time. But also we have a notice of termination when a person has done what? Has breached a term of the lease. And the necessary documents here is going to be a notice of termination of the lease. So part D, the steps Benson would have to take to retain the property in the event that his lessor in respect of property B has written to him terminating the leases and is preparing to evict Benson for non-payment of rent. So basically here we are looking at relief from forfeiture. And then relief from forfeiture, we look at relief from forfeiture. Is the documents which are going to draw is always a notice of motion supported by an affidavit, draft the pertinent document in one above. So it's always a notice of motion supported by an affidavit and draft the most. So we go to part E, whether Benson can eventually convert the acquired interest into another tenure, and assuming it were possible, the steps that have to be taken. So basically here we are looking at how do you convert leasehold to a freehold, and I think this one is covered under section 28 of the Land Act, which basically gives you how you can convert a leasehold into freehold under section 28 of the Land Act. So we are seeing part F. Benson has informed you that one of the neighbors in the land comprising Wakiso broke 321 plot 164 Busuku of plot A has blocked off the only road by which the property could be accessed. That neighbor occupying the land comprising Wakiso block 321 plot 164 Busuku is in possession of a decree of the Chief Magistrate's Court of Wakiso, granting permanent injunction against Daniel Ahumuza, restraining him from trespassing on the decree holder's land by illegally using the same as road. The only other neighbor whose land is not fully built up is comprising land comprising Wakiso. This land can be used as the next option to access the public road. However, he has refused to talk to Benson over granting him an access on any terms. So basically here we're going to proceed under the Access to Roads Act, and they give you the power. If someone has failed to negotiate, you write to the minister, sort an application, and then after that, then the minister calls you, and then and he can negotiate between you, and then this person can give you an access to the road, and draft the most important the documents. Here we have the application, which is always supported by a statutory declaration. So part G, having started the operations of a hospital on property B, the Ministry of Health identified Benson's hospital as a health facility that the government could take over in pursuit of its policy to put a functional hospital in every sub-county. The ministry intends to cause the Ministry of Finance to avail funds to compensate Benson and take over his property instead of building a completely new facility in the same area. Benson is completely opposed to this development. Benson complained to the RDC of Chankwanzi district. The RDC has sought advice from the Attorney General office. So as the state attorney working with the age advised Benson on what government would have to do lawfully to take over privately land and whether it is applicable in the circumstances. So basically here we are going to proceed under Article 26(2)(e), which provides for compulsory land acquisition, and the decision in Sumani Irumba versus Attorney General, which provides that there must be prior, prompt and adequate compensation. But also you look at the procedural steps under the Land Acquisition Act, which the government must take. There is public notice, there is valuation of the land, fair hearing, and payment, then also remedies for the aggrieved parties. So you have to look at all that process under the Land Acquisition Act, and then you advise appropriately. So let us proceed to workshop 3. The facts in workshop 2 part D will be used for this mode. By the end of the workshop, you should be able to explain the basic principles of enforcement of provisions of leases, demonstrate the remedies available to LSC that has revolted on terms of the provisions of the lease. So basically, we looked at remedies, which we discussed as relief from forfeiture. You can ask relief from forfeiture from court. Then draft a document that would enable the LSC obtain the remedies upon default on terms of the provisions of the lease, and talk to the notice of motion supported by an affidavit. Then recognize and deal with issues relating to the process of obtaining remedies available to this C that has revolted on the terms of provisions of the LSC. So the ISCO issues, of course, lawyer student overcharge. That's where you always begin from. Then also the landlords should follow the provisions of the Landlords and Tenants Act, as well as the tenants should also be compliant. So basically, that's an analysis of land law. Please, if you want a discussion, you can come and we shall add in our discussion group. Basically, members pay 100,000 per month to support our research and also support the data. But it's a very useful group because you get here from different campuses, as well as you get summarized notes always on Saturday and then Sunday for both workshop 1 and workshop 2. So we also have online discussions on Google Meet on Saturday from 4 to 6 p.m. as well as on Sunday from also 4 to 6 p.m. where we get to interact and we hear what came out from different farm loans, and then we reconcile. So please, it's a very good investment you can make. You know, you only have one chance to pass the bar course, and it should only be this year. So if that can meet your budget, please hit me up on the number on my YouTube. Then I will guide you more. Thank you for watching this video. I didn't take it for granted. Please stay blessed.